Welcome to the Napa Legal Weekly Podcast. I'm Mary Margaret Bush, Napa Legal's Executive Director.
And I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal. You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty through the lens of faith-based nonprofits. This week, we'll be covering a newly passed state Religious Freedom Restoration Act, this time in Wyoming, which makes the 29th state to pass one. We'll be covering a lawsuit against the state of Delaware involving speech restrictions on pro-life pregnancy centers. And then we'll be covering some updates on the Corporate Transparency Act.
Thanks, Frank. So we'll start off with the Wyoming Religious Freedom Restoration Act. This act passed in Wyoming this week, and it is an important victory for religious freedom. So, to talk about Religious Freedom Restoration Acts, I want to just start by setting the stage. Religious Freedom Restoration Acts, both at the state level and the federal RFRA, are the pillars of religious freedom today. So, it's really important as an advocate for religious freedom to understand both the foundations of RFRA, how we got here, and what some of the current debates around RFRA are. So, to set the stage, the First Amendment of the Constitution was interpreted by the Supreme Court in 1990 in the case Employment Division v. Smith, and it set a bar for government burdens on religious freedom. And the rule that the Supreme Court basically said was that when the government burdens religious freedom through a rule that's generally applicable, that government law or rule is presumptively valid as long as it's neutral and does not come from a place of hostility or over animus towards religion. So Congress in 1993 reacted to the Supreme Court's bar and said, that doesn't go far enough. That doesn't correctly balance the city of God and the city of man in these situations where a government law is going to really significantly burden religion. And so they set a new standard that holds the government accountable so that even when a regulation burdens religion only incidentally, there's at least a level of accountability to make sure that religion is considered and that the rights of religious people are protected. This came up often during the pandemic. So you had rules such as, you can't bring a group of people together on Sundays, you can't sing. Well, that affects everyone, but at the same time, that's going to particularly affect people who believe, under the commandments that they need to keep holy the Sabbath. And so this balancing test is really important. But later on, the Supreme Court ruled that this act of Congress did not apply to state actors. It only applied to those acting on behalf of the federal government. But states were mostly on the same page as Congress, and they realized that some kind of accountability for the government in these balancing situations was necessary. So many states, I believe we're at 29 states now, have stepped up and created these same kind of checkpoints so that when the government enacts a law that burdens religion, there's just that extra level of consideration and deliberation given to ensure that we can all protect our religious freedom, live in accordance with our beliefs, while also observing, general safety standards or whatever the policy objectives of the government are. A lot of detractors will malign these religious freedom restoration acts by saying that they give privileges to religious organizations. That's actually not the case at all. RFRAs don't mean that religion wins. They just create a stop sign or a checkpoint to balance the factors that are at play. They ensure that the government is explaining its actions, that they're using the least restrictive means needed to accomplish important objectives, and they ensure that laws that are such as those during the pandemic where they're affecting broad swaths of people, that at least some consideration is being given to First Amendment freedoms. And these same types of stop signs and or double checks are also used for other situations, such as civil rights. We've talked in the past about strict scrutiny for what the government considers or what the Supreme Court considers historically suspect classes. And so this is not unique to religion, but it is unique to fundamental rights. And so it's not so much about privileges as it is about balancing the values of our country. So, our Faith and Freedom Index outlines the state religious freedom restoration acts that we have, all 29 of them. Some track the federal government's law identically, a few set the bar a little bit lower, and some set the bar higher. So, Wyoming's tracks quite closely with the federal government's Religious Freedom Restoration Act. It allows citizens of Wyoming to invoke the law both as a claim or a defense. And it defines state action. I thought this was interesting. The types of state action that will bring this balancing test or this strict scrutiny into play include the implementation or application of any law, state and local laws, ordinances, rules, regulations, and policies, whether statutory or otherwise, or action by a state or political subdivision, government, municipality, or public official authorized by law in the state of Wyoming. So, what does this mean? This means that if like, I don't know any towns in Wyoming, but if a town in Wyoming enacts a law that says that people can't assemble on Sundays, the government will need to show that that's the least restrictive means of accomplishing a very compelling objective in Wyoming. And so, again, it doesn't mean that religion always wins. It doesn't mean that people of faith can run red lights or anything like that. It just means that when the government burdens religion, there's a conversation around that puts those safeguards in place. So, Frank, I know you've thought a lot and written on religious freedom restoration acts, both the federal and the state level. What are your thoughts here, and what are your thoughts on the passage of this new act in Wyoming?
Yeah, I have a couple of quick things here. So first of all, it's good news, right? That the RFRA train keeps on running, right? Because there were, I think, as of 2022, there were 24 states that have RFRAs, and most of those had been passed in the years after the Bernie case in 1997, when federal RFRA could no longer be applied to states. So to see kind of this resurgence, where in the last couple of years, if five more states now have signed on and passed RFRAs. That's heartening. I want to just touch on two things. One, where I think there is an important break. You mentioned this from the federal RFRA language, small though it may seem, and then another one that is, I think, an issue to be addressed, and it's a pet project of mine. So forgive me for being a little bit on a tangent here, but I think it's worth noting. So first, like you said, I think it's really important that state action is defined pretty broadly, right? The implementation or application of any law that's going to burden religious exercise. That clearly makes it that it doesn't have to be a government enforcement action, right? The passing of a law that burdens religious exercise, the way I read this, is going to count as state action and bring RFRA defenses or RFRA claims to the table. That's a good thing. But I think the big difference from the federal RFRA here is the very clear statement that you don't need a government actor, a government agency, or the government itself to be a party to the lawsuit to bring RFRA in. That's a big problem. We discussed that last week when we were talking about that Liberty University versus Zinsky, or maybe backwards, Zinsky versus religious versus Liberty University case, where the many claims that Liberty asserted in this Title VII case was, well, this is a RFRA violation, right? This is our religious rights under RFRA are being implicated by this attempt to impose Title VII. And the judge there, I think, plausibly said, well, if that's a valid claim in itself, federal RFRA requires that the government be a party. This is a lawsuit between Zinsky and Liberty. There's no government party, so there's no RFRA claim under federal RFRA. And the Liberty Council rightly noted, like, this is kind of an awkward claim because the problem, our religious burden, is coming from a state action, right? From a federal law, in that case, Title VII, and we have no ability to invoke RFRA. So I think that I think this is a great lesson going forward, hopefully for the 21 other states who have not yet passed RFRAs, and for some of the ones who have passed RFRAs that mirror federal RFRA, that for amendment maybe in the future. But I think it's really important that requirement that the government or a government agency be a party in order to invoke RFRA is a real problem, because in the end it makes it possible for real religious freedom violations based on state action, state laws, to go unchallenged because of the way RFRA is structured. So bravo to Wyoming. I hope to see more of that. And then one thing that I'll just kind of throw out there is I think there's this ongoing problem, and Mary Margaret, I've done a lot of work on this, mostly in my own capacity, on the original meaning of religion for purposes of the First Amendment. So I think this is something that hasn't really come up in the RFRA conversation. But I think when we're talking about religious liberty at all, it's really important to have some kind of a working definition of what a religion is, right? Because my work has been mostly, like I said, on the First Amendment. But if we have a constitutional right to the free exercise of religion, but it's vague or ambiguous or unclear what a religion is, then I'm always a little bit concerned that we're um, working for needed, robust religious liberty protections, but leaving the door open for people who have either are claiming religious belief in bad faith, or even if they're not, are claiming, religious exercise protections when their belief system or what have you is not in fact a religion. I think it's a real problem, because it lets it risks that the religious exercise protections become meaningless. That being said, I think in future years we may see a Supreme Court ruling, a case go up that will clarify what a religion is under the First Amendment. But it's important to note that that doesn't solve the RFRA problem, right? Because if you have people claiming that they have religious exercise rights under RFRA who are, whatever, some kind of an atheist group or whatever, it doesn't matter if you reined in the original meaning of religion for purposes of the First Amendment, because what matters here, this is statute, is what's the meaning of religion in either the federal RFRA, right, in the 90s, or in this case, what's the meaning of religion in 2025, when the Wyoming legislature passed it. I think it's something that it's worth paying attention to for states to maybe consider as they're looking to pass RFRAs. Because if you look at the statute in Wyoming, it defines exercise of religion, but it kind of is a self-referential definition, right? The exercise of religion means the practice or observance of religion, including an act or refusal to act that is substantially motivated by a sincerely held religious belief. Um, doesn't tell you what a religion is under the statute. So it's important. And it's also important, again, to distinguish that the meaning of religion for purposes of the First Amendment versus RFRA versus the Internal Revenue Code, when we're talking about religious purposes, they're not the same. So I've had this fight before where people will say, well, of course this is a religion. I mean, the IRS accepts it as a religion for religious purposes. Like, well, okay, but the definition under the Internal Revenue Code has nothing to do with the definition of religion in the First Amendment or in RFRA, right? So I think it's a good reminder that we need to tighten up our definitions when we're making law.
I think that's completely right, and I was just talking on Monday about, the Catholic Charities Bureau of Wisconsin case versus Department of or Division of Labor there, and that case focuses on, eligibility for unemployment tax, but the grounds that the Wyoming Supreme Court upheld the denial of the exemption on was that Catholic Charities isn't a traditionally, or I think their exact words were, "isn't a typical religious activity." They weren't doing traditional religious activities, typical religious activities. And the Supreme Court granted cert in that case. And if you look at the actual facts, they don't seem particularly important. It seems like kind of a niche tax issue. But I think the Supreme Court granted cert for exactly the reason you said, Frank, which is that there's been too much havoc wreaked by the ambiguities in the definition of religion, especially in this post Christendom world where um, the efforts of enemies of religious freedom to confine protections to the four walls of a house of worship have been so vigorous. I mean, we're constantly seeing attacks on religious exemptions, attacks on, groups like Catholic Charities, humanitarian aid, the foster care system in Philadelphia. Saying, "Oh, these aren't the kind of activities the First Amendment protects," which is completely wrong. They're exactly the type. I mean, that's what it means to be a person of faith, and all of us who are people of faith will be very concerned if we reach the throne of God and all we have to say is, I showed up at a house of worship periodically. That's not gonna that's not gonna cut it in most faith traditions. So I think you're right. The reason the Supreme Court is stepping in here is because this issue is so important and so timely, and so the ambiguities have just, I think, been exploited, and that needs to stop. And hopefully it will this term.
No, that's a great point. I just want to complete this discussion before moving on by saying that I know we just went off on the definition of religion. I think it should be a statutory priority, but really, I don't think any RFRAs have addressed this question. And overall, this is a good RFRA. I just want to say that, like, the takeaway from this is not the Wyoming RFRA, missed the ball, especially the clarification that you don't need a government actor as a party to use the RFRA. It's a really good law. So that was my little nitpick because I think it's an important issue, but overall, I think it's a really good development. So moving on, I want to talk about this recent lawsuit in Delaware. There were a group of pro-life pregnancy resource centers represented by attorneys from a firm called Sims Showers, as well as the Alliance Defending Freedom. They recently filed a lawsuit against the Attorney General of the state of Delaware. I hadn't come across this law until our associate sent this case over the other day. I think it's really interesting. And it was reminiscent of some other cases that I'll get to in a minute that we've covered in the past. So the lawsuit challenges a Delaware state law that essentially forces pregnancy resource centers to post this long, burdensome disclaimer in more than one place. It has to be on their entrance, it needs to be in at least one waiting room, and it needs to accompany certain online materials like social media posts and things. So right there you have, it's not a one liner, it's a long disclaimer, and it's got to be posted all over the place. And the disclaimer must state that the facility, quote, is not licensed as a medical facility by the state of Delaware and has no licensed medical provider who provides or directly supervises the provision of services, unquote. So the pregnancy resource centers have to post this even if they have registered nurses on staff, which is an interesting point that we'll get back to in a minute. And then the other fact that's worth noting in this case is that the requirement, no surprise, does not apply to facilities that provide abortions in the state of Delaware. So in the lawsuit, the pregnancy resource centers note that the US Supreme Court has ruled against an essentially identical law in California about 7 years ago. The arguments are that the law violates the free speech clause as well as the free exercise clause, that it's forcing the centers not only to speak, but to state untrue information a lot of the time. And the other issue, of course, is that this is viewpoint based because it's targeting pregnancy resource centers, but seems to exclude abortion facilities. So I think it's a pretty cut and dry case. Um, it's disturbing for several reasons, and I just want to note a couple of things. We'll be watching this as this case develops. It's still fairly new, but I want to point out a couple of things. So for one, you have the general issue of forced speech, right? Of course, it's free speech is not an absolute. And there are certain instances where I think we can all kind of find examples where it would make sense to require disclaimers, right? If it's not clear that a facility is not, in fact, a licensed medical facility, if it looks like a big emergency room and there's no doctor on staff, like it kind of makes sense to say this is not an emergency room, this is a resource center, right? I could see one line there. I'm sure we could think of a lot of other examples where some notice required by law makes sense to avoid medical catastrophes of somebody being in the wrong place at the very wrong time, right? But here, I think we have a problem both of the actual necessity of the law as well as the scope of it. So, for one, is this really necessary? I mean, pro life pregnancy resource centers, it doesn't look like a hospital. People aren't going there. I can't imagine a scenario where somebody's having like a medical crisis, needs a surgery, and the first place they walk into is a pro life pregnancy center and they're confused about where they are. These are places where people are looking to learn about alternative options to abortion. They may ask about services, but they're not usually going here again with a medical emergency, looking for some kind of procedure that needs immediate care. So I question from the beginning whether people are really confused about these places and are going to be in danger if there's not this long disclaimer. Um, Plus, I think there's also, like I said, the truth issue that the statement required is that there's no licensed medical provider who provides or directly supervises the provision of services. That might not even be accurate. I know, I'm sure Mary Margaret, we're familiar with a lot of pro-life pregnancy centers, and a lot of them have either pro bono or staff, doctors, PAs, nurses. And again, I'm no medical professional, but I think those are licensed medical providers. So I think that to say if you're a pro-life pregnancy center, you're not an abortion provider, you need to have this disclaimer. If you have a nurse or a doctor in the building, that's not even an accurate statement that you're forcing them to make. So I would have to dive in and make sure that that's accurate. But from what I've read in the lawsuit, it appears that this disclaimer applies across the board to all pro-life pregnancy centers, whether the statement is actually true. So that's an issue. There's also the scope issue, right? If some disclaimer is necessary, it's a burdensome thing to have these long disclaimers that you have to repeat all over the place. And again, if the interest that we're trying to protect is medical health, right? The health of the people who are coming into this place who are maybe looking for emergency services. I think the less burdensome and the more rational thing to do would be, okay, you can have a disclaimer that's either you know, on the intake form or just the intake staff who meets you at the door tells you, like, just so you know, this is a pro-life pregnancy center. We offer resources. We're not a licensed medical facility. We can't do surgery. I think that covers it, right? To have these long notices and to say, got to be on the door, it's got to be in the waiting room, it's got to be on your social media posts. It just kind of seems to be overkill. And I guess I'll leave it at that. And then uh, Actually, before I talk about my last point, Mary Margaret, do you have anything to say about the scope or the necessity or anything that we've covered thus far on this?
I do have one thought on the scope. I mean, First of all, I think this is absolutely shameful, and unconstitutional, and I went back when I was reviewing this to the NIFLA versus Becerra case from, 2018, and so the standard of review in compelled speech cases is that if it's content-based, in other words, if it's targeting speech based on the communication that's being made, like the substance of the communication, that those laws are presumptively unconstitutional. So I am taking the Supreme Court at its word, and I am presuming that this is unconstitutional because ADF points out in their brief that the law applies to pregnancy centers about communicating about their care, and it targets only them. It doesn't target, for example, abortion providers are exempt as applied from this law, and so it's a content-based regulation, and there's just no place for it, and I'm so dismayed and sick, honestly, of the targeting of pregnancy resource centers, and it's so it's anti-life, it's anti-family, it's anti-woman because these are places people go because they want choices, they want options, and so to continue to harass them is just despicable, and I don't think I don't think this case is this regulation is going to stand for very long. It has absolutely no constitutional support, and I'm honestly shocked that the Delaware legislature even went here, you know? It's ridiculous.
Yeah, no, I think that's absolutely right. I mean, it's clearly viewpoint based because it excludes abortion providers. But the and right, and this reminds me of some cases. You're right, the NIFLA case in 2018, I believe. But then more recent cases, because it's so obviously a viewpoint based targeted law, these things get shot down and killed pretty early when somebody challenges them. Right, the two cases that came to mind were that the Sisters of Life case in New York was that in 22 or 23, where it was kind of similar. There was a particular burden that was regarding turning over your policies and your information on people who had visited there and what you were telling them, right? The New York attorney general was enforcing this against pro-life pregnancy centers, but abortion providers were excluded from that too. And the Sisters of Life came in and challenged. I think Beckett was on that case, and New York backed off and settled it pretty quickly. And you also had the Bella Health case, which is in a slightly different venue, right? But where progesterone was banned as a reversal of the abortion pill unless a whole bunch of Colorado boards and agencies signed off on it as an effective reversal, even though it's obviously a low side effect, low risk kind of normal hormonal treatment that Colorado left in place for anything other than trying to reverse the abortion pill, right? It was fine to prescribe progesterone in a bunch of other cases, but not if you're using it to reverse the abortion pill. Again, clearly viewpoint based, right? You're trying to target one specific use of something that you're otherwise saying is fine. So that one also, I think, ended pretty quickly. I anticipate that this Delaware one will also end pretty quickly. But yeah, to your point, it's really awful to see these blatant targeting laws that they're likely not going to stand. There's precedent directly contradicting them, and the boldness of saying, no, we're just going to pass this law that clearly targets the viewpoint we don't like, but the people on the other side of the same debate who run clinics, they're exempt from it. It's just awful.
It really is, and the Bella Health point is you're right, Frank, further emphasizes the strengths of the pro-life organization's position here. I remember from the district court opinion in that case that the judge said, "When the legislature enacts a law knowing that it's going to burden primarily or exclusively people of faith, that strict scrutiny applies." And so by extension, I think strict scrutiny would apply in this case. I don't know if Delaware actually has a RFRA or if there are any faith or if there are any free exercise related claims in this or if it's just focused on the speech issue. But I think under that reasoning, there's just further support for the pro-life organization's position because um, this is targeting a viewpoint. This is targeting people of faith since since many people's faiths teach that life deserves dignity and should be protected. And so yeah, it's just deeply problematic.
Yeah, and I think this one's gonna go down. It could go down on several separate grounds. I just checked. Delaware does not have a RFRA. But again, I mean, you have the religious exercise constitutional protections, but then also you just have the straight. There are so many problems on the free speech side, right? Like it's compelled speech, it's compelled false speech in a lot of cases. I think this one's gonna go pretty quickly.
Well, Related somewhat on the free speech case, we'll close the free speech issue. We'll close today with an update on the Corporate Transparency Act and its impact on nonprofits. So, some of our fellows, Sophia Skoke in particular, have written on the Corporate Transparency Act and what nonprofits need to know about it. While in general, 501(c)(3)s are exempt from the reporting requirements, some friends of ours, Tyler Martinez and Brian Hawkins, recently wrote a piece explaining that the Corporate Transparency Act actually can very deeply impact the stability of 501(c)(3)s and, in particular, the privacy of their donors. So the way this would kind of the structure that leads to this issue is that many philanthropists use LLCs to handle large donations. In some cases, they may be money donations. In other cases, it might be real estate or some other kind of in-kind donation. But the CTA's reporting requirements will actually impact these donors and undermine donor privacy because the individuals covered will be required to be disclosed under this, and their donations will be tracked by federal agencies. I think the specific agency is called FinCEN. And so this is troubling. There has been some litigation trying to stay the enforcement of the Corporate Transparency Act, and I think the Trump administration said they're actually pausing enforcement. The specific litigation related to the stay, Top Cop Shop versus McHenry, the Supreme Court recently like denied or like left the preliminary injunction in place in that case. So the litigation on the merits is continuing. This reminded me a lot of the Americans for Prosperity versus Bonta case and the other related Thomas More Law Center versus Bonta cases from 2020. So those cases looked at what kind of free speech protections do donors have under the First Amendment, and particularly in the context of government mandated disclosure regimes. And the foundation of those laws was an NAACP case where I believe it was a state regulator was trying to ask the NAACP to turn over their membership lists, which was, at the time quite clearly sought for the purpose of harassment. And the Supreme Court in the AFP Thomas More case held that exacting scrutiny requires that government mandated disclosure regimes be narrowly tailored to the government's asserted interest, even if not the least restrictive means of achieving that end. So that's the standard that the CTA philanthropic requirements are going to have to meet in order to remain effective. So we'll see if the CTA can survive that. And yeah, the litigation on the merits is continuing, so I could see in a future term the challenges to the Corporate Transparency Act, particularly from the donor privacy standpoint. I think that those could end up working their way into the appellate and maybe even Supreme Court levels based on the First Amendment implications here. So I don't know what your thoughts are, Frank, on this particular law or on the Corporate Transparency Act itself.
You know, I'm always this is one of those things where opposing it immediately gets you bad press, right? Because like our friend Brian Hawkins, who co-wrote that piece in the Washington Times on this issue, he and hopefully we'll have him on to speak about this case further on the podcast, I think in the near future. But yeah, I remember he posted his article and this notice that it was being that the Trump administration wasn't going to enforce it, and it was on a social media platform, dozens of these articles of these responses saying, "Oh, yeah, how dare they try to stop money laundering, and what a great victory that, all these snarky things as if it's just this cut and dry issue. Well, as the Corporate Transparency Act is just going to stop money laundering because then we can trace, who owns all of these businesses. And I don't know. I'm not an expert in this area of law, of corporate law, but I would say a couple things. One, that my antenna goes up automatically when you have this act applying to small businesses, but most of the bigger businesses are exempted from it because it's going to be the businesses that are most burdened by it, who don't have the compliance staff or the time or the ability to do it, who are going to have to comply. And then the other thing, and this is a little bit anecdotal and maybe not the primary argument against the CTA, but maybe it is given your reference to the Bonta cases. But this it's always brought up in defense of these types of laws that, well, we're not releasing these information to the public, right, about the beneficial owners of these companies. It's just going to go into the government. And I always find it fascinating when there's this belief that there's just going to be this steel wall where only the federal government has this information. There's no chance that it'll leak to the public, or no chance that it's going to go beyond the proper agencies that are supposed to have it, because that's never how it works. These things leak all the time, and even just on the local level, I was just thinking about this. The There was an interesting battle over some homeschoolers in Pennsylvania, where there's a pretty strict regime where they're pretty aggressive in Pennsylvania about trying to gather the medical records and vaccination records and all these things of homeschool students. Won't get into the question of whether they really need those documents, but there was one recently where there was a high school graduate in a Pennsylvania school district. They're done with the school system, so they asked for their records back, and they were sent back the medical records of two other students who were not them. So yeah, this idea that government agencies just have this solid protocol and these steel walls that are going to prevent any of this information from leaking out. Mistakes happen all the time, so I'm a little skeptical um, about how well that information would be protected when the government would be suddenly given this influx of millions and millions, or thousands at least, of names and contact info and sensitive information about owners of small businesses. It makes me worried. Um, I have one other thought, but did you want to weigh in?
Yes, I'll just mention that I think you're hitting on a really important theme, which is in general, I'm quite skeptical of laws that sort of bring in the wheat and the chaff, so to speak. Well, that might work for the kingdom. On the earth, with earthly courts, I prefer laws that target wrongdoers rather than laws that are broadly written and sort of bring everybody in, good along with the bad. It's for law-abiding people. Additional burdens, I think, we should be very circumspect about imposing additional burdens, and then for wrongdoers, there can be, should, and are laws to catch them. So I always look with a bit of skepticism on broadly written laws that are going to take innocent people who aren't doing anything wrong and bring them in along with people who are up to no good. And I also hesitate to think that people who are up to no good are going to transparently turn over records to comply with reporting laws while breaking other laws that are probably even more morally repulsive. So I'm not saying I'm not a fan of the Corporate Transparency Act. I don't really have a standpoint on it, but I will say the general rule, I'm definitely over here raising my eyebrows a little bit.
Yeah. Yeah, same. I'm not an expert, but my gut instinct is that, like, my friend who runs a small family cybersecurity company, like people I know in my community who run like landscaping companies, are going to have to, report their ownership information, and then people who are actually using LLCs as shells to launder money are probably going to find a different scheme and are not going to be, you know, caught doing that. Maybe I'm wrong. Again, I'm not an expert on the enforcement of these kind of things. Two little parting thoughts on the CTA while we're here. So one, we've covered this, and Sophia covered this in her piece at Napa Legal's blog last year on the Corporate Transparency Act. But I think it's worth repeating that you have the donor problem for nonprofits if the CTA goes into effect, but you also have a direct problem for nonprofits in that one of the exemptions to the Corporate Transparency Act, people who follow this will remember, is 501(c)(3)s are exempt. So you shouldn't have to report, beneficial owner information. And beneficial owner doesn't really make sense when you're talking about a nonprofit because nobody owns it. So it ends up meaning people who have control over it. It often will implicate a chairman of the board or an executive director or something will end up having to give their information. You would think, okay, we're in the clear because 501(c)(3)s are exempt. The problem with this is that the way it was written, it doesn't exempt from the CTA organizations who exist for charitable, religious, educational purposes, right? The pieces of 501(c)(3). What it exempts is people who are actually exempt under 501(c)(3). So the way the act was written, it was ambiguous as to whether, because the idea was you had to report beneficial owner information within 90 days, I believe, of the act going into effect, or within 90 days of the organization coming into existence. And so the question was, well, after the CTA goes into effect, what if a nonprofit forms, right? Once you form, the clock is ticking for the CTA. The chances that an organization is going to form and incorporate, apply to the IRS, and get their IRS determination letter within 90 days. I mean, you've been a practitioner in this field more than I have, but it doesn't really happen. I think under 90 days is not likely. So I think you're left with this problem where 501(c)(3)s, especially if you have a big donor who's chairman of the board who wants to remain more or less anonymous about their involvement, and all of a sudden you have people who now have requirements to make an initial filing under this CTA, even though they're supposed to be an exempt 501(c)(3). So I think that's a problem. It's an ambiguity that should be shored up in the statute. But which brings me to my last point on this is that the Trump administration has been in office for about 6 weeks now, so things have moved at lightning speed, right? So the preliminary injunction was lifted. The Trump administration directed the Treasury Department not to enforce against Americans or American businesses who don't file. They said they were going to limit enforcement to foreign companies. The issue here is the same issue that we've seen in this flurry of executive orders over the last few weeks, is that understandably the administration has a lot of priorities and they're acting at, like I said, lightning speed. But eventually most of these things have to be shored up by the legislature. We don't want to be in this position where we have the CTA and a lot of problematic aspects of the CTA, and then an administration that says, well, don't worry, we're not going to enforce that, because enforcement procedures change with administrations, they change with priorities, they change every day. So I hope we'll see the legislature act on this. I think, it doesn't seem that the CTA is particularly popular in the current administration. So I would hope to see amendments or a repeal if the administration is serious about fixing these problems. The answer is in Congress, who passed it in the first place, not an executive action.
I was thinking that when I was working on the Wyoming RFRA summary and just thinking back to Congress acting in 1993, it did take 3 years after the overturn of Smith to pass a almost unanimously approved law, but at the same time, it was the right people doing the right thing, and even though it did take them 3 years, these days, I wouldn't mind waiting 3 years at least if it eventually got done by the right people, because I think a lot of these problems really do have legislative solutions, and we need some moral courage and and some good administrative skills in some cases to clarify these ambiguities, both here and in the case you alluded to earlier, just on the definitions of religion and whether it's tax or Title VII or whatever it might be.
That's a great way to circle back and end with a brief mention of the importance of separation of powers, right? So I suppose with that, we'll wrap up for today. So thank you as always for joining us for this episode of our Napa Legal Podcast. If you enjoy our content, we'd appreciate it if you would like the podcast and subscribe to our channel on YouTube, Spotify, or wherever you're listening. We hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and the work of faith based nonprofit organizations.
Thank you. We'll talk to you next week, and God bless.